Well, hey everyone, Professor McElroy, ready for another office hours. Um, haven't had any power blinks today, so maybe this will be an improvement over last week's. All right. So, what I wanted to do today was talk a little bit about the upcoming contract changes in Texas, and specifically, there's some Trek forms that go live for mandatory use as of July 1st, 2026. They've been promulgated. They follow the whole process, right? The broker lawyer committee makes revisions. They open it up to public comment. They get comments in. They either make changes or they don't. It then goes to the full commission, which can either approve the forms, promulgate the forms, or just give them a pass, I suppose. Um, yeah, so what I'd like to focus on today are the changes to the 1-to-4 family residential contract, which is the most widely used of the Trek forms. So what I'll be doing is I will share my screen. And first of all, what I want to do is I'll be going through the red lines today, but I want to make sure everyone knows how to get to the red lines. Back in my corporate days, red lines were, that's a major part of doing any sort of real estate contract is going through and seeing all the changes that were made. Because in the commercial realm, we don't use standardized Trek forms. We frequently don't use even like Texas Realtors forms. So very frequently, if you're dealing with a big enough entity, it's going to have its own proprietary purchase forms, lease forms, that sort of thing. So, if my clients were the tenants, they would often default to the landlord's form if they had a form. But if they didn't, they were always ready to jump in and say, "Oh, we have a form that we're comfortable with using," and we have that ready to go. So I will. What I want to do first of all is I want to make sure everyone knows how to get to the red lines, and this is just a absolutely great tool that Trek provides that allows us to see what changed, what was added in, what was taken away. This is, if you're an office manager, if you're a broker, this is a great way to do some training in your own firm. So, and you don't even have to build any extra material. It's going to be there, right? So let me share my screen, the Trek website, right? This is the Trek website that everyone knows and loves. And to get to the forms, we just go down here. Let's go to the contracts, and let's look at the 1-to-4 family residential. And again, you'll see the effective date here, 7/1/26, right? If you're wondering what other forms recently have changed, we'll just look at this effective date. So the amendment to contract, farm and ranch. I don't know too much about farm and ranch, so I don't want to pretend like I do. New home completed construction, new home incompleted construction. These are, and what you'll notice is you have the same form with two different effective dates and two different form ID numbers. So here on the 1-to-4 family, 20-19 goes into effect 7/1/26. That's when it's required for mandatory use. You could start using it now. Then the prior version, 20-18 of the 1-to-4, was effective back in January of 2025. So they'll have the old version and the new version until the new version becomes mandatory. So if we want to see what else, so all of these basically were changed and updated. And we'll see why here in a minute when we go through the 1-to-4. We have the contract addenda. See what here has changed. The addendum for backup contract changed. Addendum for property subject to a mandatory membership in a property owners association, aka the HOA addendum, that changed. All right, did see any other ones there? And let's see down here what else is new under the other forms. The seller's disclosure about groundwater and surface rights. So this is, you'll see this form ID 61-0. It's a brand new form, y'all. Maybe we'll come back to that one after the 1-to-4 family. And that's the big one here. All right, so let's go back to the 1-to-4 family and look at those changes. I say, okay, well, this is where I would click to download the form. Where do I see the changes? Right here. And by the way, the instructions, always good to read instructions, right? 2019, which is the new version, is available for voluntary use until July 1st, 2026, when it becomes mandatory. So you don't want to use the prior version after July 1, 2026. You'll be violating the License Act. Oh, no. But right here, you can see the red line for 20-19, which is the new version. So if we click on that, Fantastic. Then what we'll see here is we will see the date when this was drafted up. Anything added is going to be underlined and in blue. So right away we see that improvements now includes generators, right? So usually when changes are made to like this, there have been questions as to whether generators included uh, property that was attached to the real property. And in this case, now they're saying, yes, that's the default assumption. All right. Now this initially looks like a lot of changes to this area, but realistically, the main changes seem to be that option fee is no longer a capitalized term, right? It's now lowercase. Legal holiday is now a capitalized term. When a term is capitalized, that means it has a meaning in law specifically. And in this case, they're defining legal holiday as a legal holiday described in section 662.003A and 662.00B3B4 and 6 of the Texas Government Code. I have a question. Does everyone know how to get to the laws and see where that is? Well, how about I show you? How does that sound? So let me share this tab now. We'll just go to Texas Statutes Online. If I search for that in Google, this is my first result. And it's statutes.capitol.texas.gov. So this was the government code. They're all alphabetized, so that's nice. Where are we talking? 662.003. All right. So we want to go to chapter 662. We just scroll down. Holidays and recognitions. Dates and descriptions of holidays. There we go. So that will open up that part of the law. So here we go. New Year's Day, MLK Jr. Day, President's Day, Memorial Day, Independence Day, Labor Day, Veterans Day, Thanksgiving Day, and Christmas Day. So those are the national holidays. And the state holiday includes Confederate Heroes Day, Texas Independence Day, San Jacinto Day, Emancipation Day, LBJ Day, Friday after Thanksgiving, day before Christmas, day after to Christmas. And optional holiday includes only the days in which Rosh Hashanah, Yom Kippur, or Good Friday falls. So that's 3A. So we're looking at 3A and 3B, 4, and 6. So 3A is all of the national holidays, right? Then B4 is June 19th, Emancipation Day in Texas, aka Juneteenth. And then 6th is the Friday after Thanksgiving Day. All right. So if you were wondering what the legal holidays are in relation to the real estate contract, then that is going to be these national holidays here: New Year's Day, MLK Jr. Day, President's Day, Memorial Day, Independence Day, Labor Day, and Veterans Day. Then, of course, Thanksgiving and Christmas Day, right? And then we have Juneteenth and the Friday after Thanksgiving. So those are the legal holidays for the purposes of a Texas real estate contract. All right, back to the contract. If you didn't know how to look up a law before, I hope that made sense for you. All right, now let's look at what else. So option fee is uncapitalized. So there's several items in here now where it says an addendum is going to be going to be attached, or addendum must be used. So essentially, I think the idea behind removing these, and it's going to be added back in elsewhere, the idea behind removing these is we know that an addendum has to be used, right? So for example, tidewaters. If the property abuts the tidally influenced waters of the state, the Texas Natural Resource Code requires a notice regarding coastal area property to be included in the contract. So it, in a way, it doesn't need to say an addendum must be used, right? It's just you have to attach it to the contract. So I think that's removing some kind of language that didn't really need to be there. Then required notices under 12, and it says the following notices have been given or are attached to the contract. Yeah, so this is just removing this because now it's assuming you're going to attach the things you need to detach. Um, we did some updates regarding the seller's disclosure notice. Instead of just calling it the notice, we're calling it the seller's disclosure notice throughout. I think the idea is we are really driving home the fact that this is a notice to be provided by the seller. I know, shocking, but that is the general idea. Um, every time, I think both legal update and broker responsibility, I think Trek has really been trying to drive home lately the idea that the seller's disclosure is in fact the seller's disclosure. It's to be filled out by the seller. It's attested to by the seller, right? We need to keep that in mind. All right, then we have this separate item. So remember, we had a form that was all brand new, 61-0, I believe. Seller's disclosure about groundwater and surface water rights, which is the seller's water disclosure. This is all new information here under subsection I. Access to surface water or groundwater on the property may be regulated, restricted, or prohibited, including but not limited to the right to drill or operate water wells and the right to withdraw water from surface water sources on or adjoining the property. The party shall use the seller's water disclosure published by Trek to identify information related to groundwater and surface rights. And then we have one box only. You either say buyer has received the surface water disclosure, buyer has not received the surface water disclosure, and this gives you X many days for the seller to deliver it, or seller is not required to deliver the seller's water disclosure to buyer because all of the following are true. Seller is not aware of a water well on the property, in use or not in use. Seller is not aware of a pond, lake, or water tank on the property. Seller is not aware of any certificate of adjudication, certified filing, or permit for surface water rights associated with the property administered by the TCEQ. Seller is not aware that any groundwater rights to the property have been severed, sold, or leased in whole or in part. And the property receives water only from the following municipality, city, municipal utility district, MUD, or other special district, water supply corporation, or private water supply company. Then you would have to fill that in, right? So this is something to go through with a seller client on a listing appointment, is to walk through this. Can you say that all of these are true? Now, in your average suburban lot, it's going to be pretty easy for them to say that all of these are true, right? But if you're outside of suburbia or an urban environment, you may have difficulty with this. So if the seller can't definitively say that all of these are true, then you need to fill out a seller's water disclosure. By you, I mean the seller, not the agent. So we'll go over that once we're done with this. I think that's a good reason to do that. All right, brokers or sales agents disclosure. We just removed this instead of brokers and sales agents, broker or sales agent disclosure, remove that and said brokers or sales agents disclosure. Then we removed this language about brokers fees. So again, we remind all parties of this requirement. Texas law requires a real estate broker or sales agent who is a party to a transaction or acting on behalf of a spouse, parent, child, business entity in which the broker or sales agent owns more than 10%, or a trust for which the broker or sales agent acts as a trustee, or of which the broker or sales agent or the broker or sales agent's contract, the spouse, parent, or child is a beneficiary, to notify the party in writing before entering into a contract of sale. So essentially, if you or a close family member, spouse, parent, child, or a business entity where you have any interest, if that is relevant in this case, you're supposed to disclose it. Me being me, I vote towards over disclosure. So I would say, hell, even if you own less than 10%, go ahead and disclose that if it's a business entity, right? Even if it's like an uncle and it's not specifically required that you disclose it, I would disclose it, frankly. I think that's reasonable. I would rather over disclose than under disclose. And then this language regarding broker's fees, it says all obligations of the parties for payment of broker's fees are contained in separate written agreements. That has been removed. We will see the reason for that here in a moment. All right, 12, we've done a little tinkering. I say we, it's Trek. I don't have any involvement, right? So first, expenses. This talks about expenses, and we've removed brokerage fees from this. Don't worry, it's been moved later, right? And then we've specified that Part B is an amount to be applied to brokers' expenses other than buyers' expenses other than brokerage compensation or contributions. So now we've added in a 12B. Again, I keep saying we. I don't know. B. So I keep doing that. Trek has created an entirely new Part B, brokerage compensation. So they are essentially separating non-brokerage compensation expenses and brokerage compensation expenses, right? So now it reiterates brokerage compensation is not set by law and is fully negotiable. Each party shall pay their respective brokers pursuant to the terms of the party's obligations to compensate their brokers contained in separate written agreements. This is a great reminder. The fact that we've put this in, right, doesn't mean that we can get away from having separate written agreements for the payment of compensation from our buyer or seller clients. All right. We still need to do that as agents and as brokers. This is simply reminding everyone that this is all true, that it's fully negotiable, and that those obligations to compensate their brokers are contained in separate written agreements. Remember, if a client doesn't pay you, you have to have three things under the License Act in order to be able to sue them for your compensation. The first is you have to have a written agreement that signed by the party that's agreeing to pay you, right? Stating that the conditions under which they will pay you compensation. Second, you have to have been licensed at the time the compensation was earned. And third, you must have given them the statutorily required notice that they should either have title insurance or have the title record examined by an attorney of their choosing, right? So going on, the contributions under 12B1 and 12B2 below shall be applied to and shall not change the party's obligations to pay compensation pursuant to those agreements. And this says these contributions must be paid at closing. Seller will pay a dollar amount or a percentage of the sales price towards the brokerage compensation owed by the buyer to buyer's broker, and similar on the seller's side. I think what this really helps is you had some title companies that under the prior language, they're like, it's not clear to us based on this that we can pay out the agents at closing. This being in the contract, being very specifically set out, I think helps get around that concern. Then we have expense limitation. If a governmental loan program regulation prohibits buyer from paying charges or fees, then the amount of any concession in 12A 1B shall be first applied to pay such prohibited expenses and then to other buyer's expenses, but not brokerage compensation or contribution. This is just rewording this former paragraph B. All right. Well, obviously, you will want to get with your broker as to how they want you to fill this out, but this is going to require, because this is going to require a conversation between the buyer's agent and the seller's agent, because whoever's filling out the contract first, they're going to need to know what the agreement the other party has with their client. So they'll need to understand whether it's a dollar amount or a percentage amount and what that is. So they can accurately fill out the contract form. So this is going to be one more thing that requires discussion before filling in the form. And unfortunately, this is a piece of information for filling in the form that we now cannot put on MLS. So this is going to require an email or a phone call. I'd say preferably an email. I guess it could be a text, right? But preferably something in writing so you have that for your records. Instead of listing broker and other broker, we've changed this to, again, we now see this change to seller's broker or buyer's broker. Okay, I like this a lot better, frankly. It is more descriptive because we already talk about buyer and seller. Why not talk about seller's broker and buyer's broker? I think this makes a ton of sense. Good on the broker lawyer committee for making this, I would say, long overdue change. And instead of just saying federal requirements, we're now saying governmental requirements, because governmental requirements can also come from the state, right? What if someone's getting a Texas Veterans Land Board loan? They'll have some state governmental requirements to deal with, right? All right, so under the contact info for buyers, sellers, buyer's agent, seller's agent, we have gotten rid of, well, we've expanded the area for the agents, clearly, and we have gotten rid of fax. It's now just address, phone, and email. Address, phone, email. And it used to be implied that there was an address, then a phone, then email, fax with a copy to your buyer's agent at. Now we get full addresses, phone numbers, and emails for all parties, including all parties' agents as well. It's a great idea. Any of you still rocking a fax out there? So before I go through this, let's see what was removed from paragraph 22. That is this. So it used to just be checkboxes and names of different addendums and documents and everything else that could be attached to this. But now it has been divided out into little categories. So we have a financial category, which is third-party financing, addendum for sale of other property by buyer. I mean, you can see these, right? Then we have leases, additional tests and reports, statutory disclosures and notices, and then other. Great. I think this is a great way of organizing all this information. Very cool. And what else do we have? We now have some updated broker information. Instead of just broker information, right? It now mentions broker contact information. The brokers in the sale are broker firm represents seller, broker firm represents buyer, and we have the option here for intermediary as well. Again, I think this is really smart. If this is an intermediary situation, we would know by this time, right? So this is yet another way to get that information across to all the parties involved. Super smart. Option fee is now lowercase. Earnest money is now lowercase. Contract is lowercase. Yeah, so just making some legal changes there. All right, so I would say not crazily scary, right? Hope everyone feels that way. Let's go look at that new addendum that everyone has. Other forms. There we go. Non-addendum. Seller's disclosure about groundwater and surface water rights. So this is a brand new form, so there's no red line because it just is the document. All right, let me zoom in. This is a quick 2-pager. This just defines everything. What is surface water? What is groundwater? What is a water well? And basically, it says information. This just asks you to fill this out, right? Typical seller's disclosure. A question: is any portion of this located in a groundwater district? Either yes, no, or unknown, right? And if yes, identify the district and its website. Then question, the kind of typical question along the lines of, is seller aware? Seller aware is always yes or no, and that's true in the seller's disclosure notice as well. And then if the answer to 2B is yes, then you have a lot of different things to fill out. Is seller aware? Is seller aware? Is seller aware, right? Does seller own? Now this is information. Does seller own any surface rights? They have to pick yes or no. It can't be unknown. They should know. Similar to, is there a pond, lake, or whatever? And then fill that out. Same thing with the seller's disclosure. What I would say is just make sure that they are, make sure that they're filling this out to the best of their ability. Right? That's all you can really do. And if they have questions, assist them as best you can, but remember, any of these seller disclosure notices are theirs alone. All right, well, this is a bit of a quick one, but timely at minimum, right? Unlike more timeless talks. All right, well, hope this was helpful to everyone. I'll be setting up something for next week too, so keep your eyes on your email. If you like this and are not a subscriber, I would encourage you to subscribe. That helps me get the word out. Thanks so much.